Hello, everyone. My name is Mike Hamilton. I'm the VP of eDiscovery at Exterro. I welcome you to today's eDiscovery Day webcast, the 7 most important eDiscovery cases of 2022. And thank you all in the audience for participating this year in the 8th annual eDiscovery Day. We'll get started with the webcast in just a moment. First, a few brief reminders. All the lines have been muted to reduce background noise. We do encourage you to submit questions at any time through your webinar control panel. We'll do our best to work those in throughout the discussion, but if we have time left over, we'll save those for the end. This webcast is being recorded and will be posted along with a copy of the slides and additional resources to the eDiscovery Day website, and that's www.ediscoveryday.com. We'll also be sending you a link to those materials a little later today. And on to our next slide. We'd like to thank our eDiscovery Day sponsors, EDRM, eDiscovery Today, ACEDS, and Exterro. Without these organizations' support, this webcast would not be possible. We do encourage you to learn more about our sponsors and the services and technology they offer, which can help your organization improve your eDiscovery knowledge and processes. So with that, I'll hand it over to today's webcast moderator, Doug Austin.
Thanks, Mike. And I will introduce our wonderful panel here. And they not only do a great job of discussing our cases every month, but they make it fun while doing it. And I will start with Mary. Mary Mack is the CEO and Chief Legal Technologist for EDRM. Her certifications include the CISSP, Forensics, and Computer Telephony. Mary is the author of A Process of Illumination, The Practical Guide to Electronic Discovery, and for over 10 years, co-edited the Thomson Reuters West Treatise, eDiscovery for Corporate Counsel. With Kaylee Walstead, she co-hosts EDRM's podcast, The Illumination Zone. She's an Illinois attorney with her JD from Northwestern Pritzker School of Law and has the smoothest hello opening of a webinar of anyone in the business. Welcome, Mary.
Hello.
Hello. Hailing from the great city of New Orleans, Tom O'Connor has stewarded the Gulf Coast Legal Technology Center for over 3 decades and has a great YouTube channel called the eDiscovery Channel for long-form interviews of industry thought leaders. He's a sought-out consultant to some of the largest cases, including most recently the opioids, has recently published a book titled eDiscovery for the Rest of Us, and is apparently a fabulous crawfish cook. So howdy, Tom.
Hi, Doug. Thanks for the intro.
And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, and also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a U.S. magistrate judge in the Southern District of New York after 23 years, writing many of our most significant eDiscovery opinions and creating valuable resources on boilerplate objections, 502D orders, and of course, technology-assisted review. And he's a big proponent of, advocate of Rule 1 in dealing with judges. Hello, Judge Peck.
Happy to be here and happy that I think my volume is working much better than on the special master webcast a little earlier today.
You're sounding great, so we're going to run with that. Yes, absolutely. And here are the case law topics we're going to be talking about. We'll be discussing those over 7 case law rulings, and the 7 rulings we picked each address a different important and compelling eDiscovery issue. Instead of talking about them here, we'll just get into them in a few moments. But just a reminder, we do welcome questions, and we'll take on questions as we can, either during the course of the webinar, or we'll try to reserve some time at the end. And just a reminder, we will also send out slides to the participants tomorrow, so look for that. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. That's true on eDiscovery Day or any day that ends in a Y. And quick shameless plug warning, we're in the final couple of days of the 2023 eDiscovery Today State of the Industry Report Survey, sponsored by EDRM. Takes literally 1 to 2 minutes. Please consider participating, and you'll get a free copy of the report when it's published in January. To find it, simply go to this morning's eDiscovery Day post on ediscoverytoday.com, all one word, no dashes, and look for the survey link at the bottom of the post to take the survey. Better yet, follow eDiscovery today and you'll get all our reports for free. And thanks for considering. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistant site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 26,000 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. Finally, 6 of the 7 cases we're discussing here come from the 10 monthly webinars we've conducted this year on the EDRM Bright Talk Network, where we covered 63 total cases, plus we're covering 1 new case today we haven't previously discussed. Each of the webinars is linked here that you can get access to when you get the slides, and that totals roughly 11 hours of case law commentary you can binge watch if you're so inclined. That's more binge watching than the latest season of Stranger Things. So with that, let's get into the cases. Here's a case involving claims for sex and disability discrimination regarding an employee of the defendant who was terminated. While she was still employed, the plaintiff started coordinating with coworker Lee Mudrow to gather instant messages from her work Slack account for use in potential litigation. The plaintiff confirmed her intent to sue in communications with Mudrow in May 2018, but didn't retain an attorney to file the lawsuit until July 2020. This case was notable in that the defendants moved for both Rule 37E and Rule 37C1 sanctions, alleging that the plaintiff failed to take reasonable steps to preserve and produce ESI from a number of sources, including 109 unsent Facebook Messenger messages with Mudrow, Telegram Messenger messages with Mudrow, and at least 4 covertly audio recordings of meetings with GoDaddy employees, as well as emails between the plaintiff and Dr. Rhodes, who was treating a condition she claimed was caused by the defendant's insistence that she work on certain days. Arizona District Judge David Campbell knows a bit about Rule 37E sanctions, as he helped draft the changes to Rule 37E back in 2015, and he provided a very detailed breakdown of each of the alleged failures by the plaintiff, including noting that plaintiff tried to conceal the existence of Telegram Messenger communications from defendants, and in her tardy production of Facebook communications with Mudrow, plaintiff manually deleted the exchange that referenced her and Mudrow's communications on Telegram. She then unsent her side of the exchange to prevent Mudrow from producing the same messages in response to defendant's subpoena. So Judge Campbell found intent to deprive regarding the Telegram messages as well as other ESI sources, and also applied sanctions under Rule 37C1 as well. So he issued those sanctions against the plaintiff, including an adverse jury instruction at trial based on plaintiff's deletion of several ESI sources, including Telegram, and issued other sanctions as well, including attorney's fees and retention of a forensic evidence expert. So Tom, do you think the plaintiff's statement in one of the messages that she is the smartest person technically in the room came back to haunt her here?
Well, it didn't help when, as the judge pointed out, several of her responses to discovery or not producing discovery were based on, well, I don't remember, I'm not sure I did that. She kind of used I'm not that technically skilled necessarily as some sort of an answer to some responses. So yes, in that regard, I believe it did. I should point out though that I think that probably, and this is totally guesstimation on my part, the genesis of that was, you might remember that in the decision, the judge also quoted a message between the two of them where she told her friend, I know they're monitoring all of this. I know they're listening, recording, checking our chat messages. They're watching everything we say, so we have to be careful about what we say. And then she sent a message saying, oh, I'm the most technically skilled person in the room, when she was fired for lack of technical expertise. So I do think her original estimation was a zinger at the employer, who she felt was eavesdropping or listening in on, not necessarily eavesdropping. But
Right.
yes, then it will come back to haunt her. Yep.
Yeah, I would agree. And yeah, and the judge pointed out that she claimed lack of technical expertise while at the same time
Right.
saying in that email. So Judge Peck, with so much spoliation and failure to produce so many different ESI sources, should Judge Campbell have considered terminating sanctions? And if you were judge, would you have considered them?
Well, he certainly could have. I mean, I will note that whether under 37E1 or 37E2, the rule says that the court may impose certain remedies or sanctions. It's not a must at all. The judge has a great deal of discretion. The other point, which I think is why Judge Campbell did not go for the terminating sanctions, is plaintiff's misconduct did not in any way go to whether the defendant actually did discriminate against her, whether for disability or sex discrimination. So with that, more appropriate perhaps to let the jury figure out whether there was any evidence in GoDaddy's records that would support the plaintiff's claim, and her misconduct was peripheral to that question. So I think he did the right thing.
Okay, yeah, that makes perfect sense. So Mary, should the plaintiff's lawyer have been more active in stopping her from spoliating so much evidence, or was it too late for him to do much given the fact that he wasn't brought in until 2 years after she started gathering messages for the case?
Well, I looked at some of the dates and I don't think it was totally too late. And it is dangerous to allow a client to preserve in place, especially a technical client with hubris like this person had. I mean, at that point, you want to get everything that you can copied and out of their hands. As Judge Conti related earlier this morning in the judges roundtable, if a cell phone's going to go missing, or there's a potential that it can go missing, forensically back it up. And Judge Matthewman was advising to consider withdrawing if a client doesn't want to play by eDiscovery rules. So this attorney got the case 2 years in and needed to make an assessment. And at that, I think they were a little bit lax in not realizing that they didn't have everything. And I might add that this case is a delightful romp through all sorts of new data types. And I highly recommend reading the case in its entirety.
Yeah, I agree. It really does. It covers the gamut. It's certainly that's why it's one of the top cases of the year. A comment from the audience, she could have been alone when she said she was the most technical person in the room. Well, that was clever. So very nice. All right.
Thomas Jefferson quote, huh?
Right, exactly. There you go. So we'll move on to the next case, which is a form of production dispute that received a lot of comments, and not everybody agreed with the ruling. Here, the plaintiff, who was a former Gannett account executive, generated and printed reports of her own performance metrics and requested the same Salesforce data for certain other Gannett employees for purposes of comparison. The defendants asserted that the plaintiff's reports weren't freestanding fixed reports, but were screenshots of the Salesforce dashboard that displays the user's real-time data. So they said they couldn't generate the reports the plaintiff requested and could only provide her with Salesforce's underlying historical data exported to a Microsoft Excel spreadsheet, which they'd already produced. After a telephone conference with the parties, Judge Hammer ordered the defendants to produce the reports in screenshot format in addition to the Excel spreadsheet format already produced to the extent possible, as well as schedule and take a Rule 30b-6 deposition of a defendant representative on this issue if they maintained that it couldn't be produced in the screenshot format. The defendants appealed Judge Hammer's text order on the grounds that it required them to produce ESI in a second format in contravention of Rule 34b2e3, and that they couldn't produce it in that form anyway. But New Jersey District Judge William Martini stated in upholding the order, Defendants have not persuaded this court that the text order is clearly erroneous, contrary to law, or an abuse of Judge Hammer's discretion. On the one hand, they argue that the text order impermissibly requires them to produce ESI in a second format, but on the other, they continue to argue that it's not possible to give plaintiff this actual information in the form of screenshots of the Salesforce dashboard due to the dynamic nature of the platform, noting that defendants had the option of providing a Rule 30b-6 deposition on Salesforce's functionality and reporting, and Judge Martini also noted the defendants' previous willingness to sit for that deposition. So Judge Peck, you cleverly noted when we originally covered this case that Judge Martini was neither shaken nor stirred by the defendants' arguments. Is there an argument they could have made that would have made a difference?
I think so. They could have argued that because the Salesforce database is dynamic, that the screenshots that they could take today would not have been comparable to the plaintiff's screenshot, a year or however long ago it was when she took it. They also failed to present any evidence to the magistrate judge about how the Salesforce database works, and then tried to present it to the district judge, who quite properly noted that appearances before a magistrate judge are not just, a practice run or whatever, and that if you don't present evidence before that judge, you cannot use it to seek review in front of the district judge. So certainly there are two forms. Production argument was the weakest of any of the arguments they could and should have made.
Yeah, absolutely. And you bring up that what they could have presented there. And Mary, as Judge Peck noted, Judge Martini noted that the defendants failed to present that information, the certificates and exhibits regarding Salesforce functionality to Judge Hammer. So do you agree? Did they cost themselves with that omission?
Absolutely. And it may be obvious to a Salesforce user that's used the product for a couple of years, how it works and its dynamic nature, but someone who's never seen it before would not understand that. So I think it's really important to understand what platform, what data type, and what understanding the magistrate judge might have, and make sure that the information's in front of them that they can make a decision on.
Yeah, absolutely. And you note the dynamic nature of the screenshots. So Tom, I'll ask you, since those screenshots in Salesforce are a dynamic representation of data at a given point in time, do you think the defendants can even do what the plaintiff's asking for?
Well, there's a question in my mind here, two things, and I guess my general answer is maybe. First of all, we said that the plaintiff, who's a former account executive, generated and printed the reports. How did she do that if she's a former plaintiff or former employee, right? Did she do them when she was employed in anticipation of this? And, I'm just interested in that. The second is, if they're in fact performance metrics, the question I would ask is, did their HR department do any of that? Did they capture in some sort of a report format performance metrics? You would think that they would. And were those available? So maybe not screenshots, but the information might be available in some sort of another format at the company. So, data's data, and data is rarely lost. There, I wouldn't exclude the possibility it could be had. But a specific screenshot, sure, of course. If it's dynamic, then it's gone. Unless they use the way back. Oh, wait a minute, that's later.
Don't get ahead of us now. Yes, yes, and I like your maybe answer, but at least you didn't say it depends, because we save those for later, right? So yeah, absolutely. It certainly seems like the defendant could have handled things differently and maybe come up with a different outcome. So very interesting case and a fun one to talk about, and it got a lot of play this year on eDiscovery Today. And we will move on to the next case, which does take us way back to January when the ruling happened. And as I recall, Tom, you suggested this case back then. So it's a contract dispute over the terms of an online auction where Henderson Auctions advertised and hosted the auction on its website. But when the auction participants clicked on the link to bid, they were directed to Proxy Bid, a third-party website where they could view the auction's terms and conditions, including a term declaring that bidders would be liable for only 20% of the bid price in the event of a breach of contract, which came into play when the defendant refused to pay for the module that proved too difficult to remove from storage. At trial, the defendant introduced the auction terms and conditions in two forms, one as an internet printout labeled Exhibit 41, and two as an archived web page from the Wayback Machine. Exhibit 41 was introduced through the testimony of Henderson's office manager, who got them from ProxyBid's website since they weren't on the Henderson site anymore. The district court ruled that she had properly authenticated Exhibit 41 because, although she wasn't its author, her job description indicated that she was a proper custodian. The district court also characterized that the archived web page from the Wayback Machine was a source whose accuracy cannot be reasonably questioned under Federal Rule of Evidence 201 and entered judgment for the plaintiff in the amount of $35,500 plus costs, which the plaintiff appealed. The Fifth Circuit Court of Appeals, finding that Martin had no personal knowledge of the terms applicable to the auction, among other things, ruled that the district court abused its discretion by relying on inadmissible evidence when it reduced Weinhofer's damages, also ruling that Exhibit 41 did not fit under Rule 803's exceptions to the prohibition for considering the evidence hearsay. Also, the court, citing the Wayback Machine's terms of use, which disclaim any guarantees of accuracy regarding its content, stated, "Here there was no testimony to authenticate the archived web page. Our sister circuit's decisions that the Wayback Machine is not self-authenticating are persuasive in the context of judicial notice." So they ruled that the district court erred because a private internet archive falls short of being a source whose accuracy cannot reasonably be questioned as required by Rule 201. So Mary, in a case with Judge Grimm a few years ago, he ruled evidence from the Wayback Machine was admissible. Is this a case of inconsistent rulings, or were the circumstances different in that case that led Judge Grimm to do differently?
Well, what Judge Grimm said in that case is that the plaintiff had not presented evidence that the Internet Archive was unreliable or biased. And the plaintiff neither denied that the exhibit represents the contents of its website on the dates in question, nor come forward with its own evidence challenging the veracity of the exhibit. And so under those circumstances, he felt that the affidavit from the representative of the Internet Archive Company was sufficient to satisfy Rule 901. So I think it's a case of yes, you put out the Internet Archive, and then you put out your the information to support that, and something has to come back and say no, it's not right. Mm-hmm. And in this case, I think that's what happened.
Sure. Yeah. Well, in this case, they put out the Internet Archive, but didn't have the evidence, didn't have the supporting information to back it up. It seems like, which is why the Fifth Circuit ruled the way they did. So,
and Doug, Doug, if I could jump in, I would just note that Judge Grimm's opinion in Lorraine against Markell, the Internet Archive discussion was all dicta. Lorraine was a 5-page opinion that became a 100-page opinion when Paul attached, in essence, a law review article type discussion of evidence and evidence admissibility. So technically what he said was dicta, but for anyone who needs to learn how to authenticate all types of evidence, read that opinion.
All right. Great point, Judge Peck. And I think if I recall correctly, Judge Grimm is now officially retired, Judge Grimm, as of today. So
No, I think it's December 31st, but I
December
could be wrong.
31st. Okay, I had heard November 30th. So all right, he's still an active judge at this point. And you
No,
know,
you can't believe everything you read on the internet.
that's true. Indeed, I think I saw that on the Wayback Machine. I don't know. Fair point. So, Tom, do you think the Fifth Circuit reversal sets an extremely high bar for authentication of evidence? And if so, should it be that high?
No, I don't. I mean, first of all, there's two things going on here. One's authentication, one's judicial notice. On authentication, they said what I think has been the standard for a long time. The person had no personal knowledge of the terms applicable to the auction, and then they had to search a website, and that refreshed their memory. So I'm not sure that that's any huge change in how to authenticate information. The judicial notice is a little bit different. I think it's, it's although related to the authentication, but they said quite frankly that the thing that hurt them, I thought, in looking at the Wayback was that the Wayback machines terms of use disclaimed any guarantee of accuracy.
Right.
So if the site itself is saying this isn't necessarily accurate, then how can you use it for judicial notice? And two points on that, as Mary pointed out, in Judge Grimm's decision, they had a certification or an affidavit from somebody at the Wayback Machine as to the accuracy. I wonder if these terms of service or this terms of use came in to cut that off at the knees from going forward, and being dragged into further adjudication. I don't know when those terms of use came into play and whether they were even there when Judge Grimm made his decision. But again, as Judge Peck pointed out, it was dicta, so it wasn't really to the point of the decision in Lorraine anyway. So.
Sure. So Judge Peck, one of the things I was curious about, the district court cited FRE Rule 201 in making its ruling, but why isn't Rule 901 more applicable here since it addresses authentication of evidence?
Well, 901 would be applicable if the party had presented any evidence under the various ways that one can authenticate under Rule 901. This would seem to be a 901 subpart 9, evidence about a process or system, but that, as both Tom and Mary have talked about, requires some testimony from the Internet Archive in order to authenticate what was pulled down off of the Internet Archive. And I will note, this is one where a little bit of thinking ahead. I had a case recently at DLA where we were looking to use information from the Internet Archive and looking at their terms and conditions for like $100 per website. You can get an affidavit from them authenticating what they captured and what is now available. So penny wise, pound foolish, that's what the party should have done. And for those interested in where that Wayback Machine name came from, if you're of a certain age, you may remember the old Rocky and Bullwinkle cartoon show where the use of a Wayback Machine to have the characters go back to ancient Greece and other sites in history what was a feature.
And Judge, who ran the Wayback Machine?
Peabody, the dog.
Professor Peabody,
human,
yes, and his
yep, and his human Mr. Sherman.
Yes, indeed. So a question from the audience, with Wayback Machine being deemed at minimum an iffy choice for admissibility, what's the best way to submit an active website as evidence? So obviously, if it's still on the website, What's necessary to authenticate there?
I mean, if, in civil litigation, there is no reason you can't get the opposing side at a deposition to authenticate the website. If not, there are various service providers that will capture websites at a certain time, do it in a forensic way, and then they could testify to it as well.
Yep, absolutely.
I suppose if it's possible, try to get an affidavit similar to what the judge just said about the Wayback Machine, something from the site itself, right?
Sure.
Saying this is true and accurate representation.
Yeah, and websites also track when pages are loaded and updated and so forth. So you could have a trail there as well. Great question. We better move on so we can get through all our cases. So our next case is a case from Illinois District Judge Ian Johnston involving claims of discrimination and wrongful termination of the plaintiff. And here, an incident happened between the plaintiff and a coworker where two sets of witnesses had differing accounts, with three witnesses who were white claiming the plaintiff put his hands on the coworker, and three other witnesses who were African American claiming he didn't. The defendant ultimately chose to believe the three white witnesses, and the plaintiff was fired. Even though three security cameras that were aimed at the area of the incident, the defendant presented no evidence that any of its employees ever attempted to view, preserve, or recover the footage before the plaintiff's termination and before the video was lost for good, nor was it preserved to address his EEOC complaint or eventual lawsuit. Even though the plaintiff had verbally requested the general manager review the video recordings, and a week later in a document complaining about race discrimination, twice requested a review of the video recordings that he claimed would clear him of wrongdoing. Judge Johnston evaluated Rule 37E's 5 threshold requirements, and on the first one, the information must be ESI, he rejected the defendant's argument that the burden of proof that the video existed resided with the plaintiff, stating, under SEVA's theory, as a practical matter, the spoliation itself prevents a claim of spoliation. He also cited the plaintiff's formal letter of complaint sent the day after his termination as satisfying the second requirement, and found that the remaining three conditions had also been met. He also found that the plaintiff was prejudiced by the destruction of the video. But when it came to intent to deprive, Judge Johnson stated, plenty of evidence exists in the record that could lead a reasonable person to conclude that SEVA acted with intent, referencing how the defendant cited the seller of the video equipment as the custodian of the security video when they had no role in the process. But he also referenced Hanlon's razor, which says in its most polite form that we should not infer malice from conduct that can be adequately attributed to incompetence. So Judge Johnston decided to leave the intent to deprive decision to the jury and provided an appendix of factual findings and instruction that he planned to give to the jury during the trial. So Tom, this seems like a failure to execute a fairly simple legal hold. Why do you think parties keep failing to properly execute legal holds when there are so many resources that provide guidance on how to do it?
Well, the judge cited Hanlon's razor in the opinion, and I think that without any further comment on that standard, I will concur with that opinion.
Fair enough. Certainly, it seems like there's no lack of resources. So at the very least, it was a matter of incompetence in not doing it. So so yeah, absolutely. And so Judge Peck, with the 5 threshold requirements met, demonstrated prejudice to the plaintiff, and at least some evidence of intent to deprive, are you surprised that Judge Johnston didn't issue harsh sanctions himself?
Well, as I said before, the standard in the rule is the court may. So Judge Johnston had the discretion to do case-ending sanctions or just the adverse inference. But I'm troubled because it's not clear to me from reading this decision whether defense counsel raised the issue of client incompetence or if Judge Johnston just came up with that and Hanlon's razor himself. So deferring until later, and maybe counsel will say my client was simply incompetent, maybe counsel won't. I think that was not the way I would have gone on that. If defense counsel is willing to say, my client didn't do it with malice, but with incompetence, I'd like, some evidence or at least argument from counsel on that.
Sure. No, that makes perfect sense. Well, and Judge Johnson has seen plenty of incompetence in the past because he's obviously the judge on the famous DR distributors decision. And he certainly was expressive in that decision and going through the history. So it certainly is surprising that there wasn't some indication in there. So Mary, with the ubiquity of video in work and home environments today, what recommendations do you have for our audience for having a plan to address them in discovery?
Well, there's a couple of things, Doug. One is that your custodians may have the same technology in two places in two different accounts. So instead of looking for one account, you may be looking for two sources of data. The other thing is that video is probably one of the biggest data. The files are huge,
Right.
and if you're being charged by the gigabyte, that can really hurt. So having some way to have some early case assessment on that would be important. Your provider should be able to index and search them with advanced tools. They need to pull out the voices in order to be able to search the voices. Perhaps there'd be some image search, but more importantly than that, redactions, video redactions. So that and having a big list of all the various sources, everything from Teams, Zoom, GoTo, the push video like Bright Talk or On24, Snapchat, Instagram. You have to know what their retention is, how they're stored, and what mechanisms there are to adjust those settings or to disappear or delete or edit.
Yeah, absolutely. Oh, go ahead.
Those companies that are now recording all of their Zoom and Teams meetings are going to regret it in a year or two when they start having to comb through that for discovery.
Great point. Yeah, absolutely. Because that's one of the things that I've been saying ever since the pandemic and so many people getting on Zoom and recording these meetings. They're piling up. So yeah, absolutely. Great point. And great points, Mary. Video is, you got to have the plan up front and use the tools you can to understand what you've got before you ever get that case. So great advice. And we will move on to our next case, which is a search terms dispute in my hometown of Houston. And it had a novel way in which the court ruled on the dispute. In this purported class action securities fraud case, the plaintiffs put together a list of proposed search terms that would result in over 700,000 documents with search hits, with an additional 500,000 family member documents, for a total of roughly 1.3 million documents that the defendants would have to review for privilege and relevance. Claiming that the plaintiff's proposed list was too expansive and would result in exorbitant costs, the defendants proposed search terms that would require review of approximately 650,000 documents for privilege and relevance. Texas Magistrate Judge Andrew Edison had a light bulb moment and said, hey, I'll use the 6 proportionality factors from Rule 26B1 to decide the search terms dispute, citing his years on the bench and experience in private practice as a lawyer representing both plaintiffs and defendants in securities litigation. As you can see here on the slide, he ruled in favor of the plaintiffs in 5 out of the 6 proportionality factors, with only the parties' resources considered to be neutral. He found that there can be little debate that the issues at stake in this case are meaningful, that the plaintiffs seeking more than $1 billion in damages weighed in favor of the plaintiffs, and that only the defendants had access to the information being sought. He even let the Texan in him slip through a bit when he said, it is awful likely that the sought after documentation is relevant and highly probative of plaintiffs' claims and defendants' defenses in the case. And regarding whether the burden or expense outweighs the likely benefit, he said in ruling for the plaintiffs, the discovery door has been flung wide open and plaintiffs should be allowed to probe inside. The purported damages in this case are huge, and that indicates to me that plaintiff's proposal is proportional to the needs of the case. So Judge Peck, both parties provided search term hit counts as part of the consideration for the court. If you were ruling on this case, would that have been enough for you, or would you have expected more information from the parties?
I mean, hit counts tell part of the story, but just by themselves, they really don't let you get to the answer. Cost is obviously a factor, but more important, you know, is there a very high hit count? Because these are really, really good terms to use, and the data is very rich. That would incline me to say you got to look through all of it. On the other hand, if one took a sample and saw that out of, you know, each 100 documents that the hits come from, 3 of 100 are relevant, or even 13 of 100 turned out to be relevant. Now that means they should be going back and refining the search terms. So hit counts alone don't tell enough of the story.
Yeah, absolutely, I agree. And you know, certainly if you're going to make an overbroad argument, doing that sampling to illustrate that seems like the best first step to take to do that. So absolutely. So in that vein, Mary, do you see any issues with using the 6 proportionality factors in Rule 26B1 to decide the search terms overall, or would it have been better to break down the terms and rule on their scope individually?
Oh my gosh, talk about opening the door. I can't even imagine how much time it would take to do 6 proportionality factors for all of the search terms.
Well, perhaps
Yeah,
not.
absolutely not. I think, wasn't it Judge Facciola said that that's where angels fear to tread? Isn't that right? Yeah.
Yeah,
Yeah, so
absolutely. Yeah.
I'd say no.
Say
Yeah,
no.
indeed.
Just say no.
Oh, go ahead, Tom. Yes, just say no. Absolutely. Tom, given the aggressive nature of claiming damages, how much importance should that factor have as part of a proportionality analysis?
Well, I don't think I don't think there's a specific answer to that. I mean, there's 6 factors, and the judge is going to weigh them all. And the judge, of course, has experience in doing this, and you know, understands how damages are claimed in at the onset of a case. So, you know, I think this is well left to the administration of the court to use his or her expertise to balance them up.
Sure. Well,
I'm a big believer in having, you know, judges have discretion from my former life. But it seems to me the way Judge Edison used these 6 factors almost became generic. And that it seems to me, even in a big dollar case, one should be looking at, you know, weighing whether this part of the discovery process is proportional or not, and not just what he essentially said was this is a you know, multi-million or billion-dollar case, therefore everything is fair game. I don't quite think that's the way the 6 factors should work.
Yeah, no, that's a great point. So yeah, I initially loved this case, but as we've talked about it over 2 webinars now, I've started to like it less. So so it's kind of interesting how getting your perspectives on it can kind of influence me. So appreciate the comments, and we will move on to our next case. And this case is it's the most viewed case law ruling on eDiscovery today so far this year. And it's one we just discussed with the actual case team that worked on it on an EDRM webinar 2 days ago. So definitely encourage you to go check that out because it was very enlightening as to what they dealt with in the actual case. The ruling is so long that Massachusetts District Judge Mark Wolf needed a table of contents to cover it all, which is usually a bad sign for one party in terms of their e-discovery failures. He also stated that there were more sanctions in this case against defendants for failure to produce documents, quote, than any other case in which this court has presided in more than 37 years, unquote, which he said 4 times within the ruling. In this case, involving misappropriation of trade secrets by an employee of the plaintiff using the plaintiff's proprietary software to place mock trades for defendants, the defendants had a series of discovery missteps in the case. Defendant Moeller filed a sworn affidavit on behalf of all defendants, claiming to have complied with the discovery requirements set forth in FRCP Rule 26E, but the defendants kept having to produce documents as the plaintiffs discovered their existence, including 47 documents that included 14 still images of the plaintiff's system, an Excel file appearing to be an export of certain data from the plaintiff's proprietary software, and a PowerPoint that included screenshots of the plaintiff's software. Oops. They also kept supplementing with additional productions of messages from their Slack communications platform, citing difficulty in conducting discovery from Slack as one of the main reasons for the issues. Eventually, the court ordered the defendants to provide plaintiff with a copy of the 2019 Slack archive for searching, which, as you can see from the 4th bullet point, uncovered a lot of stuff, 87 empty folders and a smoking gun message, which, as you can see here, as they're talking about creating another algorithm from scratch to that's not from IP, is pretty significant. So regarding all the defendants' discovery misconduct, Judge Wolf stated, defendants' repeated misconduct occurred despite 2 orders to review their document production and, if necessary, supplement it as required by Federal Rule of Civil Procedure 26E. Moeller twice submitted affidavits representing that he had complied with those orders. He also stated, Red Wolf has been seriously prejudiced by defendants' misconduct. That misconduct has also seriously injured the court's ability to manage this case and others on its docket. As a practical matter, entering default judgments against BIA and Moeller is the only viable Rule 37b2 sanction, which he did, ordering the parties to negotiate on damages. So Mary, in the EDRM webinar on Tuesday about this case, the attorney for the plaintiff stated that the judge was initially irritated with him for pushing to compel discovery until it became clear just how deficient the discovery was. So what advice do you have for our audience on when and how hard to push to compel discovery?
Well, certainly from the beginning, you have to cooperate as much as possible and thoroughly document your cooperation and the opponent's uncooperativeness, and raise it civilly with the judge as necessary and not for stupid stuff. And have a reason why the information is relevant and necessary that you're not getting. And then when you have the smoking gun, you've laid the table out and Rule 1 can apply then.
Indeed, which we will have to get to. Judge Peck, you may want to share with the audience what Rule 1 is.
Well, Rule 1 of the Federal Rules of Civil Procedure is that the rules are to be interpreted for the just, speedy, and inexpensive resolution of matters. But what those who attend our regular monthly case law webinars have heard me say, there is the unwritten rule that follows right after that, Rule 1.1, which I call the don't piss off the judge rule. And violating several court orders is certainly a violation of my unwritten Rule 1.1.
Yes, and clearly that's what the defendants did in this case. And one of the things, Mary, that I noted from the webinar on Tuesday is that second bullet point, those 47 documents that included all that damaging information. The attorney for the plaintiff in the case talked about that as being kind of a turning point where the judge really began to see just how deficient the discovery was. So very interesting discussion of the case, and certainly recommend everybody check that out. So Tom, one of the defendant's contentions that was related to this difficulty of producing information out of Slack. Do you think that was a legitimate issue or more of a dog ate my homework excuse?
Well, I think there should be a door number 3 in your question, Doug. Um, all of us at some point, I would believe, when we were 15 or 16 years old, used the dog ate my homework excuse, which is really just an excuse for I was too busy having fun this weekend to do my homework. And you know, I didn't get to it, but not out of any reasons of malice or even incompetence, but I was having too much fun being a kid doing something else. In this case, as you pointed out, when they looked at the entire Slack archive, it appears the defendants were talking about how difficult it was simply to buy themselves more time to delete data. And I think that's, as I said, that's a whole different issue that deserves its own door number 3, which the court, I think, constructed, opened, and employed.
Sure. And yet they managed not to delete a very critical message there that we see in bullet point 4, which is why I think they're the new gang that couldn't spoliate straight, perhaps.
Hanlon's razor. Hanlon's razor again.
Indeed. Indeed. So Judge Peck, you know, Slack is becoming more common as a source of ESI in cases. I think we've had 3 or 4 cases this year that included it, but it's still relatively new. So how much leeway would you be inclined to give a party with discovery issues on newer sources of ESI?
Well, initially, I'd be inclined to give them more leeway than if they said, as they used to say back in 2006, this newfangled email, I don't know how to deal with that. Well, no one's going to say that now if there are any companies that still use email in light of text messages and Slack and the like. But, you know, how many times can you just say, I don't know how to handle this, particularly once the judge has ordered you to deal with it? At that point, not only do the federal rules of civil procedure come into play, but the ethics rules come into play. You need to know how to deal with it. And if you don't, you need to hire somebody like Tom or whatever to help you deal with it. So you get a certain amount of slack in this area, pun intended,
Ooh.
but it's not indefinite.
All right.
I put on Doug's toes with the puns there.
I tell you what, I can't believe I missed that one too. Judge Peck always picks up the ones I miss. So nicely done and well put.
Nicely done. Well played.
Yes, absolutely. Well, technology competence. I mean, obviously, we know about the accommodative rule. Of the ABA rule. So obviously, that's one of the things that comes into play here, and certainly they paid for it. Very great case. Definitely recommend you all check it out. And I will move on to our last case, which is one we haven't discussed before. A TAR dispute with an interesting ruling by the 2 special masters. In it, the defendants applied in August to implement their proposed protocol for the use of TAR after the application of search terms for its document production going forward. The plaintiffs opposed the use of TAR by defendants and instead requested that defendants be ordered to proceed with its search term and linear review, or be ordered to implement the TAR protocol to the full custodial set of documents. The defendants argued that applying TAR after the application of search terms is standard practice, and that as the party responding to discovery, they were in the best position to determine the best review methodology, and they cited 4 cases where that approach was approved. The plaintiffs argued that the application of TAR to the full corpus of documents prior to the application of search terms would create no additional burden on the defendants and would increase the accuracy of the review, and cited a case of their own. In referencing the 2 older cases the defendants cited, the special masters referenced the defendants' lack of cost data to support their position and the age of the cases, as well as a declaration from the defendant's eDiscovery vendor stating the declaration does not detail how those costs will be increased or decreased based on the implementation of TAR either before search terms are applied or after they're applied. In ordering the defendants to continue with their originally chosen review method, linear search term review, the special masters stated implementing TAR at this stage after the application of search terms opens the door for potential disputes that may arise related to the accuracy of the review process and will further delay the completion of discovery and drive costs upward. Because plaintiffs did not bargain for this at the outset over a year ago, it is inappropriate to force them to accept it now. So Tom, is this a bad ruling by the special masters, or did the defendant drop the ball in how it pursued its search terms plus TAR approach?
Yeah, I think the latter, more the latter. We talked about this when we were discussing what cases to discuss, the four of us did. And I said, I didn't see this as a number of commentators in social media did as an anti-TAR decision. I saw it as a you didn't make a good argument decision. Specifically with regards to, first of all, you didn't give me any cost analysis whatsoever. And then second of all, the time frame. You brought this up. You should have brought this up a year and a half ago. The quote I zeroed in on was, quote, defendants fail to explain why they should be permitted to continue using search terms when TAR is generally recognized as more efficient. What's the advantage of using both search terms in TAR? No explanation has been satisfactorily provided. End quote. That's not an anti-TAR sentiment. That's you guys are not making a really good argument here why we should do this now.
Okay. So part of the argument, Mary, from the defendants, the special masters analyzed the two older cases that the defendants submitted, but not the two newer cases. Was that unfair, since part of the reasoning in rejecting the two older cases was the age of the cases?
Well, I think the age of TAR cases is important because the technology and the processes and protocols are developing, and so an older case might have some good things to say about a particular matter, and it's all fact specific as the opinions states. But the thing in this case that really caught my eye is that this opinion says you have to keep the large corpus of archived data. That's terabytes and terabytes of data, just in case there's disputes. Basically saying that it wouldn't cost too much. So I think that's one of those things I think we'll need to dig into a little bit more.
Yeah, agreed. Well, and to Tom's point, that they could have played up that cost, and the fact that they didn't do it certainly seems to have cost them here. So Judge Peck, are you surprised that the special masters didn't provide an alternative for TAR only, since the plaintiffs identified that as an option that was acceptable to them?
I mean, I guess since the defendant was so against that, there was no point in the judge saying, well, you could do that because the plaintiff is okay with it. The problem I have here, and I wish the special masters had made it clearer, is this is more a situation, as was the case in the Valsartan case, also out of the District of New Jersey, where the parties had agreed on an ESI protocol. Presumably, and certainly in Valsartan, that protocol was so ordered by the judge, and then wanted to somewhat unilaterally deviate from that protocol and throw TAR into the mix. On the other hand, the judge seems here to be giving the party that doesn't want to use TAR a veto power in that subsequent negotiation of can we switch from review of the keywords to TAR. In addition, and again, this may be just the parties didn't make the right arguments to the special master, but to the extent the master was concerned about the results of the combined process, that obviously could be tested with validation metrics, as was the case in the various decisions by Judge Francis as special master, and then the court in affirming that in the diisocyanates case, which I'm amazed I remembered how to pronounce now because it's so hard.
I'm impressed. Yes, absolutely. No, that's a great point. That was a great analysis by Judge Francis in that case, which we covered, I believe, in the last webinar we did on October 31st. So definitely check that out. Yeah, very interesting case. And just when we thought we weren't really seeing too many TAR decisions anymore, we had a few. So we are at time, but we do have a couple of questions or comments. Let's see that. So one question back from earlier, back to the Wayback Machine case. Wayback Machine has an option where you can capture a website at a certain time. Can the person who saved it be used to authenticate? I would say absolutely, and probably had they done something, if they had something like that, to back up the evidence in the Wayback Machine for that case, that might have made a difference. Would you all agree with that?
Yep.
All right. And then a comment. Actually, it's a comment from Tom. So, Tom, you referenced the website authentication issue, and you mentioned a document that Judge Grimm and Kevin Brady wrote. You want to mention that real quick?
Yeah, it was just a small monograph. I think it was only 5 or 6 pages long. Just, a lot of bullet points and checkpoints and things to consider. It's called Admissibility of Electronic Evidence. It's available as a PDF online and, from a lot of sources. But page 2, as I remembered it, after that comment or question from somebody in the audience, page 2, one of the specific data points they talk about is how to authenticate websites, and it lists, I don't know, 6, 7, 8 different ways to do that with references to federal rules and decisions. So it's like I said, it's a nice, quick little reference guide. If you've got a question about websites, that's a good place to start.
All right. Appreciate the tip, Tom. I will go see if I can find that and include a link to it when I send out the slides. So those of you who've been participating can look for that as well. So
there you go.
Yeah, very good. Real quick, there were other cases we considered as part of the potential top 7. Mary and Kaylee were quick to point out my inadvertent pun in calling them also-rans, since one of them involves discovery of a horse. But there's several very interesting cases in here, and it was a tough call to pick just 7, but certainly consider checking out some of these as well. And finally, our contacts page, we do already have a date for our next case law webinar, which is on Thursday, January 19th, back on the EDRM Bright Talk Network, because interesting eDiscovery case law rulings never end. So with that, I will thank Mary, Tom, and Judge Peck for their terrific insights as always, and I will turn it back over to you, Mike, to close us out.
Hey, well, thank you, Doug, and thank you to the great panel. What a great discussion, and very substantive when it comes to those need-to-know cases from this past year. Thank you all in the audience for attending today's presentation. We have more to come with eDiscovery Day, so please stick around. We have one more webinar, we have a couple other special events, and we have in-person events located throughout the country. So please be aware of that. Go to eDiscoveryDay.com. And again, a big thank you to our eDiscovery Day sponsors, EDRM, eDiscovery Today, ACEDS, and Exterro. Big thanks to Doug for putting this all together. So thank you all. Enjoy your eDiscovery Day and hope to see you again soon.
Thank you, everybody.
Everyone.